Hi again, everybody. It's time for another episode of Ask the Lawyer. And today we're asking, how do you know if you're the victim of medical malpractice? And then what do you do if you think you are? Well, and here to answer our questions is attorney Michael Perez with the Warshauer Law Group in Atlanta, Georgia. Michael, thank you for making some time to answer our questions today. I appreciate it.
Thanks for having me, Rob.
So let's just start at the basics a little bit. Describe, in layman's terms, what is medical malpractice and when and how does it occur? How do we know if it's medical malpractice?
Sure. Well, medical malpractice is whenever we have the exercise of medical judgment, and that exercise of medical judgment is done negligently, and then it causes an injury to the patient. That, at its core, is what medical malpractice is. And when we're talking about medical malpractice, what we're really talking about is the failure to exercise a reasonable degree of care and skill, or what's called the standard of care. If you have the failure to exercise that care and skill, and it's below the standard of care, then that's negligence, and that's what we call medical malpractice.
Sometimes medical procedures, things don't work out the way you want. Sometimes it's just what you call a bad outcome. Is it difficult sometimes to tell whether it's one or the other, medical malpractice or just a bad outcome?
It absolutely can be, and you've hit the nail on the head. There can be bad outcomes that even the best surgeon in the world, the best nursing care in the world could not have prevented the outcome, and those cases are not medical malpractice. Again, when we see medical malpractice, it's a failure to exercise that reasonable degree of care and skill, a failure to meet the standard of care. What I tell people a lot of times is if you were looking at the care in a particular situation, if you were looking at the patient's treatment by a physician or by a nurse, and you had a room of 10 objective doctors, and they were looking at that doctor's care and said, well, I would have taken the same steps. I think what this doctor did was reasonable. Then that's probably not going to be a situation of medical malpractice. But on the other hand, if you have those same physicians looking at care that happened to a patient that said, wow, I don't know what that doctor was thinking. I would not have done that. Those steps were not reasonable. Then that's a case that's more likely going to be a valid case for medical malpractice.
And I would imagine, Michael, this is the kind of thing that you really can't expect just an average person to be able to make that judgment, especially if they've been through what can often be a traumatic time in their life. That's why it's more important to get somebody like yourself who has the experience, but also a little detachment from the situation to help them figure out whether it's one or the other.
Absolutely. We have several advantages here at the Warshauer Law Group that other folks who do what we do don't. And one of those is not only do you have our legal team who has an experience in evaluating medical malpractice cases, and to evaluate whether or not there's a valid claim. We actually have an in-house medical doctor, Dr. Jen Motley, who works with all of us on our medical malpractice cases. So we really have the expertise in-house to evaluate a client's claim and to see if we can put the best case together for them to proceed to get them the compensation they need after such an awful event in their life.
What if they think, Michael, I think I have a claim, I'm not sure if I have a claim. Does it cost them anything to talk to you and find out what your advice is?
It doesn't cost you anything to talk to us, let us know what happened, and allow us to investigate that for you. We do that here every day, and we do that at no charge. And what we do is if we do find that we have a claim for you and we proceed with that claim, the way it makes sense for most families to compensate us and that makes it affordable for most families is you don't pay us for the work that we do as we do it. You don't reimburse us for our expenses as we carry forth with your case and consult with medical experts. But at the end of the case, when we're able to recover for you, we get a percentage of the recovery. And in most medical malpractice cases, that's 40%. So that reimburses us for our time and for our efforts, and then we get reimbursed our case expenses. The flip side of that is if for whatever reason we are unable to recover for a family, if we investigated your case and we determined there wasn't a valid claim, or if we took it all the way to trial and for some reason the jury didn't find in your favor, You do not owe us for our 2 or 3 years of hard work on your behalf. You don't owe us our case expenses. And so we find that that situation works best for families in what can be a very challenging time and a very expensive process.
I was just about to ask that question. I imagine it can be very expensive when it comes to doing the research and the investigation and witnesses and all that's involved.
Absolutely. In a typical medical malpractice case, just in expenses, well, the hard costs that we spend on medical records, again, expert witness testimony, travel, and the investigative part of what we do can be anywhere from $20,000 to $30,000 to over $100,000 that we spend. And again, that's outside of our attorney hours, our paralegal hours, our staff time. One of the big things that we believe about the Warshauer Law Group, and that I personally feel about all of our cases, is that we spare no expense because we understand what these injuries are like and how it changes people's lives. And so we want to do our very best and put our best efforts into your case to make sure that we can get the best result possible.
Michael, something just occurred to me that I think maybe when it comes to somebody suspects there might be medical malpractice, things didn't work out the way they thought, they may think, well, doctors take an oath. Aren't they obligated to tell me if there was a mistake that happened? Hospitals, nurses, whoever the healthcare professionals are, wouldn't they tell me if something didn't go right? What's your answer to that?
Well, certainly we would hope that. And in fact, most of the medical organizations have guidelines that speak to that. The AMA, the American College of Physicians, the Joint Commission, which accredits most hospitals, have guidelines that say that whenever there's been an unanticipated outcome, that the healthcare professionals, the doctors, the hospitals should disclose that to the patient and talk to them about what happened. Unfortunately, what we find in most of our clients' cases is the exact opposite happens. Everybody clams up, bottles up, and doesn't say what happened, doesn't talk to the family, or doesn't give very confident answers about what happened. And so a lot of times people call us, and the first thing they say is, I just need answers. I need to know what happened to my loved one. We hope that we can provide those answers through our investigation into their case, looking at the medical records, looking at what happened, and exploring the medicine of it. We can help give those answers that a lot of times healthcare providers are not providing because they're afraid of what's going to happen.
Great information as usual, Michael. Thank you so much for taking some time for us today. I do appreciate it.
No problem, Rob. Take care.
That's going to do it for this episode of Ask the Lawyer. And my guest has been attorney Michael Perez of the Warshauer Law Group in Atlanta. If you want the best information about medical malpractice, or you're ready to choose a lawyer that lawyers choose, just go to askthelawyer.com. Also, please take a second to like, share, and subscribe to our YouTube channel by clicking below. Thanks for watching. I'm Rob Rosenthal with AskTheLawyers.com.